3 of At Your Service with Haber and Martinez. I am Haber, and as you can see, there is no Martinez today. He may or may not join us, but I do have a special guest off to my left, maybe your right, depending upon how your screen is justified, and that is Carlos Canet. Carlos is a friend and a colleague. I've known him for better than 30 years now. I first met Carlos when I was a young attorney. Kind of hard looking at myself in the image here, thinking of myself as a young lawyer, but there was a day back in 1991 when I got my ticket, and I wanted to know as much as I could possibly learn about DUIs. And Carlos at that time was with what was the preeminent DUI defense firm, probably in the country, but certainly here, Essen and Essen, under the late, great Richard Essen, Alav Hashalom Rip. Richard was a wonderful man, and he brought up some of the best defense lawyers, DUI defense lawyers in existence. And Carlos was one of those guys, although Carlos originally cut his teeth at the Miami-Dade County Public Defender's Office, where I believe he started in 1983 under the tutelage of also the great Bennett Brummer. No offense to Carlos Martinez, who has filled those shoes absolutely wonderfully. But the Miami-Dade County Public Defender's Office has produced some of our best defense attorneys, and Carlos's education under Brummer and then followed by Essen and Essen allowed him to open up his own practice, Carlos A. Canet, PA, and he does mostly DUI work, but he also does different types of criminal felony cases in both state and federal court. He's admitted not only in the state of Florida, but also in every federal circuit that involves the state of Florida, which would be the Southern District of Florida and the 11th Circuit Court of Appeals and the United States Supreme Court. So with that said, Carlos, thank you so much for coming today. I really appreciate your sharing some time on a Monday afternoon with the folks.
Thank you for having me, Michael. It's a pleasure. Thank you.
Thanks. So what I titled today's show was Day Drinking, Night Drinking, Whatever. Just don't drink and drive DUI/BUI cases in Florida. As I said, for the audience's benefit, this is, you are one of the masters, one of the true DUI gladiators. So it's always a pleasure to be able to pick your brain. And one of the really nice things about criminal defense litigation as a lawyer is that we tend to be more fraternal as a group, I think, than our civil counterparts. We're constantly leaning on each other, and we're constantly seeking advice from each other. And overall, we're constantly eager and open and willing to help our colleagues, whether we know them or not. I get calls from people from outside of this, all over the state of Florida who I've never met. They know me because of my online presence. And because of the way that I was raised in the system, I treat them the same way, which is offering whatever I can to help, if I can help. And so you have definitely been that type of a mentor. And in your 40 years, I mean, it's hard for me to imagine how many DUI and BUI cases you've been involved in. I mean, it's got to be in the thousands.
I tried doing that count once or twice, and I always conclude, well, did I actually reach 1,000 yet? But it's got to be getting close. I know I've got over 100 jury trials, that's for sure. So yeah, it's been a pretty active career, I would say.
So I noticed when I was scrolling through your website, which, by the way, folks, on the news ticker, you have all of Carlos's contact information. I encourage you to take a look at his website. He has a carve out on there for called Court Wins. And if you click on that, it highlights some of the very interesting cases, obviously not all of them, but some of the very interesting cases that Carlos has been involved in, and some of the things that he's personally done that have really taken a baseball bat to the trajectory of DUI litigation in the state of Florida. Actually, we have a kind of flow chart of things that we hope to discuss, but while we're here, maybe we can just hit on this real quick. I don't know if it's your biggest case that you had in your career, but it's certainly one of the most impactful to all defense attorneys, and that's the Meador case. Can you tell the folks a little bit about that?
Sure. It certainly is. It's probably the most famous one. It's the one that gets the most attention, and it's the name that I see tossed most. But back in 1995, another lawyer who you know, Mark Gold, who runs the Ticket Clinic, and I read this paper by this professor at Clemson, and he was basically bashing the research of the Southern California Research Institute, which was who were contracted by the federal government to come up with the test battery that is now so famous, horizontal gaze nystagmus, walk and turn, and one leg stand. Okay, so Marceline Burns and Moskowitz out in California at California Berkeley, did the research that allowed them to use the grant money, right, that they got from the Department of Traffic or Transportation to do the research, and like I said, the rest is history. They came up with the test battery. They put out two very important. Well, they put out two studies, and then a third one, which was kind of like a wrap up between 1977 and 1981. So Spurgeon Cole, which was the PhD at Clemson, who somehow got his hands on this research, saw it for what it was. It hadn't been peer reviewed. The methodology was nothing close to being scientific. So he tore it up, and Mark and I got a hold of his, like I said, his paper, and we decided to file a motion based on it. And the motion landed in front of Judge Zebedee Wright, which I don't know if you remember Judge Wright, Michael. But he was one of the more amenable judges that we had back then, and we thought he was the best guy to do this in front of. So believe it or not, the state went ahead and spent the money and hired Marceline Burns herself to fly to Fort Lauderdale from California. And we had this, 3-hour hearing where Spurgeon Cole testified, Marceline Burns testified, and that was the appellate record that was created. We won. Zebedee Wright granted the motion, tossed out every field sobriety exercise in his division. Of course, the state was, did an immediate appeal. The case landed in the 4th DCA. And I remember doing the arguments that morning in front of Judge Pariente, who eventually went to the Supreme Court. And I can see it like it was yesterday, standing there in front of that panel and arguing field sobriety exercises. And they gave what I thought, was the best opinion they could, given the record that we gave them, because the record that we gave them was not that good. Okay, we Mark and I walked into this thing, and the prosecutors walked into this thing assuming that everybody that was listening knew what we were talking about. Okay. We didn't have the cop, which would have made sense, the cop come in to describe exactly what he did in Meter's case. Well, I had him walk a straight line. I had him stand on one foot. I scrolled the pen in front of his face. And they complained about that to us at oral arguments. I mean, Pariente did pretty loudly. She said, "What were you guys doing here? I mean, this record is really nothing. We don't know what this cop did. All we got is you guys talking about stuff as if, it's all taken for granted." So based on that record, they did, I thought, as best as they could do. They found that HGN was totally scientific, and, admitting that is not a question of weight. It's a question of admissibility, or testing that is a question of admissibility. The other two they thought were more mundane, that you could have somebody who's just a layman walk in and talk about, standing on one foot and walking 9 steps and then turning around and walking back. And since that time, I tried to use Kumo tires to exclude field sobriety exercises, because in reality, and this, Mike, the cops who come in and talk about this stuff aren't lay people. Okay. They sit there in their uniforms and they tell you about their training and their experience. And they went to the DUI school. They went to the advanced field sobriety exercise school. They had a curriculum. They were tested on it. They did field testing. There's nothing layman about that. Nothing. So they're giving an opinion, but they're trying to disguise it as a lay opinion. And I've tried to use Kumo tires in order to dispute that. And of course, there isn't a judge in Broward County who's willing to toss out field sobriety exercises on that basis. So I've had no success, although I think that the argument's pretty valid.
There's a lot to unpack there, so I want to dummy this down a little for our audience in case they're not aware. In virtually any DUI or BUI case, as in any criminal arrest, an officer first has to have some sort of a reasonable and articulable suspicion in order to conduct an investigation. And DUIs usually occur as a result of a traffic stop. Not always. Sometimes there's somebody sleeping on the roadside or the police respond.
Or an accident. Yeah.
Right. Or they pull someone over for a traffic violation. But whatever it is, it's generally there is some basis for the officer to have contact with the individual. And then during the course of that contact, the officer develops what we call a reasonable and articulable suspicion, or a reasonable suspicion standard. And that allows them to detain you a little bit longer than would be necessary otherwise. For example, if they don't smell alcohol, or they don't see bloodshot eyes, or they don't have any indicia of impairment, they're probably just going to keep you on the roadside long enough to write you the speeding ticket, or the weaving ticket, or the broken taillight ticket, and then send you on your way. But if they do sense those things, it gets ratcheted up to a full-blown investigation. And at that point, the officer has to figure out whether or not they have enough to establish probable cause, which is the standard for an arrest. Well, how do they do that? In any BUI or DUI case, the first thing that the officer does is they ask for field sobriety or roadside sobriety examinations. They used to be tests. They're no longer tests, thanks to Carlos. In fact, many cops still call them tests, and we are able to now get pretrial rulings thanks to Carlos and Mark. We are able to get pretrial rulings from judges where they actually have to, the state attorney has to instruct their police officer witnesses that they cannot use the word tests when they describe the field sobriety protocols, and instead they have to use exercises or exams. So that's the basic situation. And you all have seen videos or maybe experienced it, or know somebody who's experienced it or seen it on TV, where the officer gets you out of the car and they give you these different exams. And I want to go through some of them because one of our colleagues has come up with a really wonderfully descriptive and creative label for it called abnormal tests to determine normal faculties. And why do we call them abnormal tests? Well, when you go get your driver's license, they make you, they check your vision, right? They make sure that you can see. They have you look inside of a vision testing machine and read off letters like you would at a doctor's office. Well, why do they do that? They do that to make sure that when you're driving down the road, you'll see somebody on a bicycle, or you'll see a red light. They need to make sure you're not colorblind or farsighted or nearsighted, or that if you do require glasses or visual aids, that they become a condition of your licensing, right? But never in the history of a driver's license exam did any DMV officer have you stand on one leg and count to 30. Or did they have you follow a stimuli with your eyes while they shove a flashlight from an angle into your other eye? Or did they have you walk in a line in a particular manner? So we call these abnormal tests. And why do we have them? So that officers can decide whether or not you're DUI, whether or not they can present additional evidence in your DUI case. And these things can be very, very damning. Would you agree with that?
Absolutely. Absolutely. I mean, they originated, as anyone might have guessed, in the medical field. Doctors use certain hybrids of what the cops use in doing evaluations. HGN, for example, comes straight from medicine in order to determine mentation and whether or not your balance is okay or affected by some outside component that's affecting your ability to keep your balance. So they measure the nystagmus of your eyeballs. The others, though.
Well, let me cut you off on nystagmus for a minute, because I want you bring up a really interesting point. So what's going on here with the nystagmus test is this is actually a scientific examination that's used in the medical field.
Right.
Yet I don't believe that in the history of law enforcement there has ever been a medical doctor that carries a badge. It just doesn't happen. It doesn't mean that these guys can't be trained to see jerking of an eyeball. But it does mean that they're not doctors, and it doesn't necessarily mean that what they're seeing is either accurate or correlated with what it is that they're looking for, which is alcohol or controlled substances, right? Because you can get nystagmus from any of a number of things.
Sure, and the wrestling match between the science and are we going to allow the cops to investigate DUIs any way they want to, is what we see in the different court opinions that deal with nystagmus. For example, in the 4th DCA, nystagmus is not coming in unless the cop is a DRE. And even then, I dispute. In the 3rd DCA, nystagmus is coming in because like I said, the different districts have different ways of grappling with, are we going to let the cops do what they want to do in order to snag DUI defendants or subjects, or are we going to respect the science?
And so to dummy that down a little bit more, just so the folks understand what Carlos is saying is, Florida has 20 different judicial circuits. So for example, right here, Broward and Dade have their own judicial circuit. Dade is the 11th, Broward is the 17th. They're independent and sentient. Now, they're obviously all obligated to follow case law from the Florida Supreme Court, but there's not always case law on point. So each has its own district court of appeal. And here in Dade County, we have the 3rd, and in Broward, they have the 4th. The 4th encompasses a little more than Broward, and the 3rd a little more than Dade. But the point is, once you cross 214th Street or 213th Street, whatever it is, you've entered, if you're a Dade County guy, if you're a 305 guy, you have entered the twilight zone when you go into the 954 for court purposes, and vice versa. If you're a Broward guy and you cross south into the 305, you've entered the twilight zone for court purposes. So the very same situation, depending on which side of the line of County Line Road it occurs on, you're going to have two very different precedents in terms of court rulings.
True. And that's just an example, of like I said, this constant struggle between in the courts where are we going to allow law enforcement to do what they want, or are we going to respect the science?
And so, as Carlos said, here in Dade County, if you have an officer that gives you that HGN test, this guy could be right out of cop school. I mean, he could be a rookie for all you know, and they're going to let him testify. Flip side of the coin, go up to Broward County, and unless you have the best of the best of the best, which is something else I want to talk about, it's probably not going to be admitted into evidence. But I want you guys to know that DUIs are really interesting creatures. So every cop, every police officer that gets certified as a law enforcement officer has to go through a police academy. And every police academy has a DUI block. They're required to take it. It's like when you're in high school or college, there are certain classes that are mandatory that every single student has to take, and then you get a bunch of electives. This is one of the mandatory blocks. Now, it's not like they're spending 6 months or 4 years of medical school teaching this sort of stuff. It's maybe a 24-hour block, or a week-long block or a day-long block. And then there are advanced classes that officers who are really interested in doing DUI enforcement can take. And obviously, the more classes that they take, the more they learn. And at least presumably, the better they will be at the job. One never knows. But the point that I'm trying to make here is most of the DUI certified officers are what we call professional witnesses. These are not rookies. These are not kids right out of cop school. These are guys who are honed and experienced, and through beatings that they've taken through defense attorneys like Carlos and others, have gotten really, really, really good at testifying. They know how to say what they need to say, and they know how to avoid saying what's going to get them in trouble to maximize their testimony. So if you have a DUI or a BUI, this is only reason number 147 why you want to go to a guy like Carlos, somebody who specializes in this type of work, as opposed to hiring a general practitioner, because a general practitioner is not going to know how to deal with those types of witnesses. You mentioned DREs. I want to talk a little bit about them too, because DREs are even more presumably qualified DUI officers because they now have a certification. DRE stands for Drug Recognition Expert. So not only are they qualified to do the battery of examinations and all of the things that go along with DUI for alcohol, but they're also qualified to do this, at least by their departments. And most courts will allow them to tout and laud their credentials as experts in detecting controlled substances. Go.
This is true. You mentioned in a lot of instances, you might have some police officer, some kid who just got out of the academy a year ago, who's got maybe 10 to 20 DUI arrests, and he wants to go ahead and do what essentially medical doctors do, in waving the pen in front of your face to gauge the movement of your eyes in order for him to bolster his opinion that, yeah, you've been drinking or you're impaired due to alcohol. What's worse than that is the cop who thinks he's an expert, okay, because he's got all this extra training, and he's got the ribbons, and he's got the certificates, and he's got all the hours. That guy, if you really don't know what you're doing, will come into court and he will just start talking and saying whatever comes into his head, and it sounds good. And the ones that are better at it know how to sound good.
And
Sam
there
Behar,
are,
Sam
there
Behar,
are, there are a couple of them. I don't know if they still do it, but they used to bring the notebook into the courtroom with them, with all of their certifications. And as the questions were being asked by the prosecutor, they'd flip open the notebook, and so that the jury could, without publishing it to the jury could still sense what was going on there.
Yeah, you have to spank those guys. You have to see them coming. You have to have some good idea of what it is they're going to be saying, so that they don't get away with this nonsense of just coming into court and saying anything that they want to, knowing that nobody's really going to challenge them on it.
So let me give the folks a little pro tip here. This is something that you're never, well, I shouldn't say never, but you're almost never going to be told by a police officer on the roadside before you take FSTs, or if they're moored up to your boat, before they give you a marine battery of FSTs. They're probably not going to tell you, unlike with breath, which we'll get to in a bit, they're probably not going to tell you that you do not have to take those tests and that they're voluntary and that you're free to decline. They generally just tell you, we want to take these exams. Are you willing to take them or not? But they don't say to you, you don't have to take them. They're not compulsory. No, I mean, instead, there's a presumption in most people's minds that when they're pulled over and they're being grilled by 1 or 2 or 3 police officers with 1 or 2 or 3 squad cars, especially if it's at night and the reds and blues, the LEDs are flashing all over the place and traffic is driving by and you're standing outside of your car now, most people don't feel that they have the right to say no, and the cops are not required to tell you. So the pro tip is this: you are under no obligation whatsoever to take field sobriety tests. Your license will not be suspended as a result of saying no. Unlike breath, different story. You are perfectly free to say no. And more importantly, you do not need to offer the why of it. You don't need to say, no, officer, I have a herniated disc. No, officer, my knee hurts. No, officer, I drank too much to take these tests. You don't have to offer any explanation whatsoever. You're perfectly entitled to just say no. And what happens if you say no? They don't have that observational evidence to present in a courtroom.
This is true. And they're under, like you said, they're under no legal obligation to tell you that you can say no, that they're voluntary. But neither can they try to use subtle coercion in order to get you to do them. Okay. And this is an issue that comes up for me fairly frequently, and is now before the fourth on a couple of orders out of a judge in Broward County, where the officer, I mean, there's 2 ways a cop can have you do field sobriety exercises, right? There's option A and option B. Option A is, good evening, sir. My name is Officer Canet. I pulled you over because it appeared to me like you were weaving, and now I've made certain observations. It appears to me that you may have been drinking. I'm going to ask you to do a series of field sobriety exercises. Are you willing to do them? That's option A. Option B is, good evening, sir. My name is Officer Canet. I pulled you over because I saw that maybe you were having difficulty maintaining a single lane in your car. I suspect that, and I'm making certain observations so that now I suspect you may have been drinking. Look, I'm going to have you look at the tip of my pen, and I want you to follow the pen with your eyes and your eyes only. And then he does that one, and the next one, and now I want you to, stand here. There's a huge difference. And we've litigated that difference with some success in Broward County. And like I said, now it's in front of the fourth. And of course, cops are always looking to intimidate you. If you're smart enough to follow your advice, Michael, and say, guys, I know that you're just trying to do your job and whatever, but I don't think I'm going to do that tonight. Well, if you don't do them, I'm going to base my decision to arrest you just, on the observations that I've made thus far. So you understand that, right? To try to get, to break you down and to get you to submit to their authority. So granted, they don't have to tell you that they're voluntary, but neither can they use this sort of subtle coercion or, take for grantedness that you're going to do this in order to get you to submit.
But still they do. And there's always that unspoken aura of authority that many people simply acquiesce to because they feel they don't have an alternative. And it's especially daunting at nighttime if you're alone. In one of the great areas where this happens all the time in Broward is Weston, right? Sure. Those Weston DUI officers are, especially with kids, they're out on the prowl looking for them every night. They pull them over in the same area. They've got their protocols laid out. Their DUI officers are on the standby.
Boulevard, whatever, Bonaventure Boulevard. Yeah, they're out there.
Exactly. It's like easy. It's like shooting fish in a barrel for these guys.
Sure. You bet.
So
you bet.
How do you tackle that? I mean, I find in my practice, that really the biggest tool that's come to help us on both sides. Sometimes it helps the state, sometimes it helps the defense. But I've come to find that body-worn camera is really a wonderful thing. It gives me the ability to go through the officers' written reports, which they detail. I mean, the detail that they put in, these DUI officers put in, on the third step, he was off 1/4 of an inch. I mean, it's unbelievable when they do the chart on the finger to nose test and they show exactly where he touched it. So when you've got the video and you can slow it down frame by frame and compare it to those reports, well, first off, when you look at the video, half the time your client is falling all over the place, hammered. And when you're able to show that to the client, that pretty much
seals the deal
right there. But where your client is arguably or objectively not falling all over the place, where your client is responsive, and to use your example, when somebody says to a police officer, and it's on body cam, officer, listen, I understand you have a job to do. I appreciate it. I accept it. I know where you're coming from, but I have a job to do also. I'm a citizen, and my job is to invoke my rights. Yeah. So no, I'm not going to do anything. I don't want to be obstructive or offensive. I just want us both to be clear that we're doing our jobs here. When that plays out on video and it sounds normal and it looks normal, it's very helpful. But how do you deal with the roadside sobriety examinations in terms of, trying to pick them apart or if possible, to shred the officer on the stand?
Well,
setting HGN to the side for a minute,
yeah.
The traditional ones.
Well, I've learned over the years that cross-examining the officer on the minutia, right, of the way that he administered the exercise to try to get him in a gotcha moment. Oh, the instructions that you were taught say this, but you did that. And therefore your observations are compromised of my client's degree of impairment. I sort of have gotten away from that because I find that juries don't
backfire.
Juries don't really care if the guy had him walk 8 steps or 9 steps. What juries are looking for is somebody that looks like they're impaired. It's somebody that looks like the guy that they saw at the Dolphin game or the guy that they saw at the last party that they went to. And if he looks similar, chances are you're in trouble. But if you've got a guy who has trouble walking a straight line, who has trouble standing on one foot, but otherwise is behaving the way that you just described or characterized, I'll go to trial on that case. Okay, because I used to think that it was just an urban legend, and it ain't really true. But I have found over the years that it is true that jurors sit there watching these body cams, or back in the old days watching the dash cams, and they see themselves doing these same exercise. I actually like to call them tests so that I can ridicule them later on. But they see themselves, trying to walk a straight line in the middle of the night on the side of the roadway with 2 or 3 cops, staring them down, just waiting to arrest them. or trying to, or worse yet, trying to balance the entire weight of their body on the sole of one foot. And they say to themselves, I can't do that. So what they do is they focus on the person's behavior. And that's what I focus on. I try to spin their behavior in a way that I can argue, at least credibly, somewhat credibly, indicates that, look, he's not acting drunk. So who cares if he can stand on one foot or walk a straight line? Only these cops care, who are the ones that took him to jail that night. Okay. Or these prosecutors here that want you to find my guy guilty. But you can see for yourselves, he's fine. So that's typically these days how I deal with it.
I've had some success literally telling jurors, I mean, and again, assuming that you have a video that your guy is not necessarily falling all over himself, because that's the kiss of death. But if they're, at least presentable, right? And communicating and responsive. Like, for example, the initial things are really important to us. They're little things, but they're big to juries, right? Well, officer, when you asked my client for his driver's license, he gave it to you, didn't he? I mean, he didn't give you a credit card. He didn't take him 6 minutes to try and find it. He pulled it out and handed it right to you. What about his insurance? How long did it take him to give you that one, or the registration? I mean, now when your client hands the officer his Blockbuster video card from 1993 instead of his driver's license, you got a problem. But if the guy is responsive, he pulls over, he's parked normally, he doesn't exit the vehicle until he's told, he produces the documents that he's requested to produce in real time, and then you have a video that's reasonable to look at. I try to argue to the jury, you know what? This all comes down, if you've got a refusal, by the way, because it doesn't work when you've got a breath reading over 0.08. That's a different story. But when you don't have breath and you just have roadsides, or, you can actually say to a jury, look, go in that jury room and try and do these tests. Check yourselves out.
Yeah, I'm sure some of them do.
Right? Because the truth is, if you can go into that room and do those tests, then you have to kind of take yourself out of it and put yourself in it's now 2:00 in the morning on a Friday night. I've got 4 police cars with strobes all around me, 8 police officers, flashlights, radios, guns, badges, traffic driving by, and put yourself in that moment and try and perform those same exams.
Right. That's why I take for granted that jurors are smart enough to know this, that 99% of the panels that you deal with know that if they go back in the jury room and in that environment try to stand on one foot or walk a straight line, it doesn't matter if they can do it. It's great if they can't, because it helps prove my point. But I have faith that most of them will have the so what moment. Okay, yeah, here in this room with just you guys, and there's no distractions, and I'm not nervous because I have a cop who wants to arrest me. Yeah, sure, I could do it. Anybody could do it. But I like to focus. If it's a poor performance on field sobriety exercises, I'll focus on the client's behavior, normal behavior. Now, if he's got a stellar, if he's stellar on field sobriety exercises and the cop just had his head up his ass when he made this arrest, then obviously these things are the best invention for law enforcement since sliced bread. Look at how well he did on these tests that have been measured and researched. Are you kidding?
Right. That's when you use. That's when you tout the test.
Yeah, exactly.
So let's shift gears for a minute from FSTs and talk a little bit about breath, blood, and urine. Because again, remember, the officer on the roadside is doing this. He's not doing calculus, but he is performing a calculus. Most of them probably can't spell calculus. I can't spell calculus, much less do it. But they perform a calculus. And the calculus is, do I have enough reasonable suspicion that I can articulate bloodshot eyes, slurred speech, odor of alcohol coming off this individual's person, weaving? Yeah, okay, that's my reasonable articulable suspicion. Now let me give this guy FSTs. Okay, he took the FSTs, didn't perform to standards. Now the next step is going to be a request for breath. Breath is a little bit different than FSTs, because with breath in the state of Florida, they are absolutely required to advise you that you have the right to refuse. They have to read you the law that's called Florida's implied consent law. And there's actually a written form that they're going to have to use, and they're going to have you initial it and sign it and timestamp it so that they can prove that they actually read you your implied consent. Then you have to decide whether you want to blow or not blow. And there are consequences, obviously, both ways. So I want to talk a little bit about breath, but I also want to get into what happens if you refuse breath and how do we get to urine and or blood, and then the efficacy of both and how you would deal with them.
Well, the first thing that we need to remember, and this is another device that's used by law enforcement officers, is that they don't actually have to tell you that you can refuse, and none of them really do. What they do is, they'll read you the speech off the card that says, "Mr. Smith, you've now been placed under arrest for driving under the influence. I'm now requesting that you submit to a lawful breath of your test. Are you willing to follow Florida law and submit to this test?" And they leave it there, hoping that you will swallow and say, "Oh yeah, of course, of course I'm going to do your test." At the moment that the subject, who understands that it wouldn't be a good idea, says, "I don't think I'm going to do that," then he's got to read you the rest of the implied consent warning, which, of course, is you lose your license for 12 months the first time, 18 months if it's a second, and if it's a second, you'd be committing a misdemeanor of the first degree. We could do 2 hours of this show on breath testing, okay? But I'll just give you a synopsis. Whenever I see a breath test result, I compare that to the person's body cam video, and if the person is looking normal and is behaving himself, then obviously the defense is that there's a disconnect and you cannot trust this device, no matter how much you want to. And then, of course, in Florida, we've still been fortunate enough that the law reads that, it's the breath concentration, the burden of alcohol concentration at the time of driving that the state of Florida must prove beyond a reasonable doubt, not an hour and a half later when he was brought to the vat and he actually blew into the machine. And of course, to try to take the legs out from underneath that argument that's been around for decades, okay, the technology has finally caught up with it. Okay, so now the officers have, of course, body cameras that are HD with digital sound, so that they can get your client's face up close, and so that they can actually try to see for themselves the impairment. But now they have put intoxilizers in the back of SUVs, intoxilizer 8000s in the back of SUVs that are often parked. If it's not the guy with the SUV that's pulling you over, the guy with the SUV is parked close by where the car has been pulled over, and they just drive him over. Okay, so that they've tried to cut down the time between the actual driving pattern and the time of the breath test result. But there's still always a gap.
So the longer the gap, obviously, the better for us, right? But
well, it depends though, because if the gap is too long, for example, if it's an hour, hour and a half or longer, then the state will invariably argue, well, he got pulled over at midnight. He wasn't tested until 1:30. He didn't have anything to drink between midnight and 1:30. So he couldn't have been on the rise at the time he blew into the machine. That's what they love to say. So oftentimes I would like it if the test was close in time to the time of the stop, because if the results are low enough, I can argue that at the time of the stop, he's still under, and he was peaking at the time he blows into the machine.
Right. So, and of course, sometimes we use experts to assist us in explaining this to the jury, right? This is called the extrapolation or reverse extrapolation theory.
Sure. Yes. Right. And in in dealing with breath testing, I do my best to look, Mike, there were for many years, okay, I would go into a jury trial involving breath test results, and I'd have the charts, and I'd try to bring in the expert, and I'd go over blood breath partition ratios and Widmark's formula and all that stuff, and try to, create reasonable doubt using all of that by demonstrating that the science behind this machine, is not reliable. Okay, it's just a thing to sell to police agencies so that the companies that manufacture them can make money. Okay, but the science behind it, especially when you've got a blood breath partition ratio, is not really something that's been tested adequately. So for years I did that, and maybe sometimes it worked, but I've discovered that simple is better. And if I can break it down to a jury and explain to them, look, there was no witness that came in here and told you what his blood alcohol concentration or breath alcohol concentration was at the time that he was driving. They told you what it was an hour later, but not at the time that he was driving. Okay. And then have their person agree that, yeah, the metabolism of alcohol does go up, it plateaus, it comes down. I don't know where your guy was when he blew into the machine. That I think makes it simple enough for most jurors to understand.
But if your breath is really high, it's not going to make a whole particle of difference, right?
No,
When you're dealing with a 0.3, what difference does it make?
Yeah, you have to find another way. You have to find some technical problem and file a motion to exclude, maybe some administrative problem. I presently have a motion in Broward County where I'm challenging the use of breath test results and the videos inside the bats in Broward, because for decades, they never videotaped the administration of a breath test. They videotaped everything else. I used to call it the donut theory, right? They videotaped the entire donut except the most important part, which was the hole in the middle. And they came up, for years, they came up with all sorts of excuses why they wouldn't do it. Well, last October, the Broward Sheriff's Office starts videotaping the administration of breath tests at the bat. And I have to find out through some third party, through a good friend of ours, Michael Catalano. Okay. So I presently have a motion to dismiss a couple of breath test cases in Broward because of a violation of due process. I mean, the excuse that they gave me for, yeah, for decades we didn't do it, but now suddenly we are, is, oh, well, you know, now we can use the room where the cameras are. That's it. Now we can use the room where the cameras are. You know, we couldn't move the intoxilizers before because that's where we did field sobriety tests, but we can now. So I'm arguing that that's just a total violation of due process. They should have been doing this long, long ago. And in my two clients' case.
What about urine and blood? So Florida, you know, they can't just take your blood.
No,
right?
no.
I mean, unless there's a fatality, they can't just take your blood.
True. There are limited circumstances under which a blood draw can be done in Florida. One, if there's a death or serious bodily injury and the cops have PC to believe that you were operating under the influence and you caused or contributed to the cause of the death or serious bodily injury, they could, arguably, they could do it without a warrant. These days, I argue they've got PC. They need to get a warrant, and most cops are getting warrants.
Yeah, the smart ones get warrants. What about urine though? So what about a guy who refuses breath, and they say, all right, we want you to pee in a cup now?
Well, if he doesn't pee in the cup, obviously his license is suspended for a year because they read him the implied consent warning. But if he does pee in a cup, urine DUIs are probably the easiest kind to defend because the labs never quantify what they find. Okay, they identify what they find. They'll find cannabis, or they'll find delta-9 carboxy THC, which is the metabolite, or they'll find cocaine, the parent compound, or benzoylecgonine, which is the metabolite, and they'll just identify it. They will not quantify. So there has to be a connection to overcome the reasonable doubt that your client was impaired at the time of driving due to whatever they found in his urine. That's not that easy to do. I mean, for some lawyers like us, we give the state an awful hard time trying to make that connection.
Unless the client makes it real easy. So, for example, you are a medicinal marijuana user and you think, well, because I have my prescription for medical marijuana, I can use it and drive and it's not a problem. And the answer to that question is you're wrong. You can get a DUI with medicinal marijuana the same way you can get a DUI with legal alcohol.
You can get arrested for DUI, okay? And if you go ahead and provide them with the urine sample and they find, the parent compound for cannabis in your urine active at the time that they took the urine, then yeah, obviously the state has a stronger case. And if they can show a body cam demonstrating some difficulty with field sobriety exercises, yeah, the state's case can be approved.
Where I was going to go with that was, you've got your THC pen with your THC liquid ink, whatever you want to call it, oil vaporizer, or you've got your prescription marijuana pre-rolled, legitimately dispensary purchased joints, or your gummies, or your whatever, and it's there in the car. Additional proof. I mean, that's like having an open container these days.
Absolutely is. Absolutely is. There's no doubt about it. You don't want to be driving around with that stuff in your car, because even though you weren't using it, if you've got a pen or a vape, the cop is going to say, oh, I detected the odor of cannabis coming from inside the passenger compartment. And that's going to give him a reason to get you out of the car, to search your car. And, you know, and if they find carts, to try to charge you with a felony, which in Broward, we changed that a little bit. Before in Broward, if you were caught with a cart, no matter the amount of liquid that was in the cart, that was going to be a felony. Okay. Well, a guy much smarter than me, Russell Cormican, figured out that, wait a minute, if the lab can't tell you whether the liquid or the THC in the liquid is organic or chemical, then you can't be charged with a felony unless it's more than 20 grams of THC.
But that's Broward. It's not the whole state of Florida.
That's Broward, and you know, Russ filed his motion. It got granted. The state took him up. The fourth just PCA'd him. They didn't give an opinion. I got my motion granted. You know, the state took me up. This time, the fourth wrote a 10-page opinion saying why the case, you know, the trial judge did not commit error in dismissing the case, and essentially doing away with felony cart charges in Broward County. And what they did was, the way that they responded was, now they use an out-of-state lab to test the carts, to do the expensive test to determine whether the THC in it is synthetic or organic.
Well, the guy who invents the functional equivalent, or the guy or gal who invents the functional equivalent of a breath testing machine for THC is going to be very, very wealthy, I would assume.
I imagine so. I mean, it's hard to imagine that it could be done like an actual, alcohol testing machine, because there isn't, as far as I know, there isn't any sort of equilibrium that takes place in the bloodstream. I mean, you might have the THC breath for a couple of minutes, right? But that quickly disappears.
Well, maybe they can do some sort of a quantifiable munchie examination.
Yeah, something to that effect.
So it used to be, and I know it's still Florida law, that anybody who's accused of DUI has the right to request a independent blood test. So police officer says you're under arrest for DUI. You have a right to say to the officer, that's fine, but I want a blood test and I want it now.
You have to provide them, though, first with a breath test. You got to go ahead and agree to do their test. They have to get results. And then after they get the results, like I had a client up in North Florida, he did exactly what you're supposed to do. He gave them a breath sample. The results obviously were above the threshold, but then he said to the cop, this machine is nonsense. I don't believe the results. I want my own test. And the cop said, no, I'm not going to do that for you. I think these results are reliable enough. And those results got tossed. So you're absolutely right. I mean, they have to be able to give you the opportunity to do an independent test.
Now, the problem with that is two-edged sword, right? Be careful what you ask for. You might just get it.
True.
If you get that independent blood test and your blood comes back with an alcohol percentage above the legal limit, you're going to have a much more difficult time refuting a viable blood exam than you will a breath machine.
Time to settle the case.
Yeah. Or alternatively, and the other thing that's potentially even worse is they find controlled substances in your blood that wouldn't show up in a breath test, right? So let's say I take Ambien to go to sleep and I haven't taken it since the night before, but it's still in my system. They may not be able to prove that I was on it, but I certainly can't prove that I wasn't on it. And it's irrefutable that it's in my bloodstream. So if they find THC, if they find, and it doesn't really matter what it is, right? Because there's a whole list of, prescription and even over-the-counter medications that you can be taking just because you've got a cold, let's say, or a sleep aid or what have you, which are enough for the state to be able to argue contributed to your inability to safely operate a motor vehicle and therefore be DUI.
Absolutely. Or right, if you're the one who's requesting the test, the best the cops can do, on a midnight on Saturday is do a blood draw and give you the vials. Okay. And then somehow you take the vials to your own lab and they do an independent test. I mean, that's about all they can do, right? Because you're not going to turn those vials over to the crime lab in your county, because they're going to do exactly as you say. All right. But if they
So
hand
if
you
you
the
ask
vial,
for that, if you ask for that independent test, they don't have to take you to a hospital. They don't have to call fire rescue. They don't have to do anything. Just what happened?
they can, nice cops will call fire rescue. I mean, there used to be a couple of smart ass guys in Broward County many years ago who were part of the DUI task force, right? And they used to love it when they had some drunk guy playing lawyer, in the bat saying, I want my independent test. Okay. And they'd say, no problem. And the fire station was right next door. They'd have some EMTs walk over with a blood kit. They draw the blood, and then they take the blood over to the county lab, right? Where invariably the county lab is going to find that you're way over, right? Well, that's really not the way to do that. The way to do that is, no, you do the draw, give me the vials. I'll take them to my own lab. Okay?
Well, but how can you? How does that
functionally?
How does that functionally happen when you're going to be handcuffed and booked into the jail? You're not going to take your blood work with you, and if they take the blood, if they put it in property, it's not going to.
Yeah, put it in your
Well,
property.
but it's not going to be. It's not going to be properly refrigerated or maintained. So, do you then have a spoliation argument?
If it's the guys, if they use a kit, if they use the cop's kit, okay, he's going to have the antibacterial and the anti-preservative in that tube, and hopefully you're out the next morning or the next day, and you can run to LabCorp with your vial and say, here, please, could you refrigerate this quickly? I need to test it for only alcohol.
But then aren't you going to have issues on your side in trying to introduce that evidence in terms of chain of custody? How do we know that that's the same vial? How do we know it hasn't been tampered with? How, blah, blah, blah.
Michael, what's good for the goose is good for the gander. They seal that shit up. They put it in envelopes. They sign. I'll say, listen, I'll take my vials, but not before you seal it up, put your initials, put it in an envelope, give me some evidence tape. Okay. And then when I go to LabCorp, the guy at LabCorp testifies, oh yeah, when it got here, it was sealed. Seals weren't broken.
It was beautiful. It was right out of a CSI.
I mean, listen, we're talking about something I've never seen happen in a DUI case. So
yeah, it's just something I was throwing out there. So generically, when you look, if you were going to offer generic advice to someone, as assuming that you do, I mean, I don't know, a lot of lawyers don't have generic advice. What's your feeling in terms of just the average Joe? Take FSTs, don't take FSTs. Blow, don't blow.
Well, this is probably the same advice that you would give, Michael. You don't want to, in a criminal case, ever for free give the cops the evidence that they're going to use against you later on in court. So my advice has always been the same. You don't have to do the FSTs. Don't do them. You don't have to submit to chemical testing. Don't do it. Yeah, you're going to lose your license for a while. But later on in court, you're probably going to have much better chance to beat that case. Now, something that we haven't chatted about is these days, in a lot of instances, it doesn't really even matter anymore, right? Especially in Dade and now in Broward, where, unless you're going to blow over the threshold of a 0.15, diversion is going to be available to you. So, who cares if you blew or if you didn't blow,
So what Carlos is saying is my basically across the board advice. I mean, look, even a gymnast, even a professional athlete can have problems with FSTs. Again, it's not just the performance of the test. It's the way the instructions are given. It's the circumstances under which you are taking them. It is the stimuli that is going on around you, the pressure to perform. My across the board policy for people is, look, double refusals are a DUI defense lawyer's best friend. Just say no to everything. Do it politely. Do it respectfully. Don't be a wise ass. Don't offer extra commentary. I like the line about, I appreciate you're doing your job, officer. I accept it. I understand it. I don't fault you for it. But I have a job to do too, and that is to invoke my constitutional rights.
That's the way to do it, man. That's the best advice you could give somebody who gets pulled over late at night. And look, Michael, let's not give anybody a false sense of security here. if you get pulled over late at night and it's just you and the one cop, okay, that's your best chance of going home that night. Okay. But once his or her buddies show up, okay, and see that you are being investigated for DUI, you're probably going to take that ride.
And the ride is no fun. I mean, look, none of us want to see you go for the ride, but the truth is what Carlos said earlier really is the linchpin here. And that is, if you're going for the ride, it's better to go for the ride without providing the government with damning, incriminating evidence, be it field sobriety tests, be it breath results, or be it even equally bad statements.
Yeah,
the more you say, the worse it gets. When you're yammering off at the mouth and all that's being recorded and it gets played back and then people listen to it, as Carlos indicated earlier, your behavior, how you are perceived, is going to be probably more important than anything else. The calmer, cooler, and more rational and appropriate you are, the better. You know, again, when the officer asks you for your driver's license and you hand him a credit card, there's a problem there.
Oh, absolutely. And that's why I would prefer to have a case where the client is seen, you know, on the body cam acting, you know, politely, rational, you know, even under a stressful situation, keeping some semblance of cool, but having difficulty walking a straight line or standing on one foot. I would rather have that video than the one where, and this is a true story, where the guy is doing handstands and cartwheels, okay?
Just so he could prove to the cop how agile he is.
But wait, but when it looks like the cop is going to put him in cuffs and take him to jail, he gets on his knees and offers him a blowjob. Okay, I don't want that video, okay? Or he says, come on, officer, what do I look like? Some kind of N-word? Don't take me in. Don't want that video, even if he can stand on his head and do cartwheels.
There was one not too long ago here in Miami. The video was viral of a female adult dancer,
those are always fun.
performer. She got pulled over down in Flagami for speeding at 4 or 5 o'clock in the morning and hands the officer a wad of cash.
Nice.
It's on body cam, and the officer says to her, "Ma'am, I just need your driver's license and registration." She's like, no, just take that. And he's like, "Ma'am, I don't want your money here. Please take your money back. I just need your driver's license, your registration, and proof of insurance." And she, I mean, look, she was smashed. You could tell just listening to her voice, but her behavior was so bad, she wound up picking up another little bullet point I was hoping to get to, what we in the business call gratuitous charges, right?
Sure.
And those are the things that you get when you say and do stupid shit. So the less you say and do, the less likely you are to pick up a bribery of an officer charge like this woman did, or a resisting arrest charge, or a fleeing and eluding charge, or an obstruction of justice charge, or even sometimes worse than gratuitous charges, because sometimes those things can actually be helpful when the cops are overcharging you with too much stuff. Sure. You know, yeah. It can backfire on them. But what's worse is what we call being held in contempt of cop. And that's where you wind up getting tased or beaten down, and, you know, things get real bad real quick.
Don't want that.
So do you have we got about a minute and a half left. Any pro tips that you'd like to leave the audience with, apart from the obvious, which is, as we titled the show, just don't drink and drive? I mean, you know, you've got Ubers, Lyfts, Airbnbs, designated drivers, designated captains, hotels, motels, so many options other than getting behind the wheel of a car or the helm of a vessel.
Right. Well, it always helps to have some idea of your situation. If you've got it together enough that you can assess what the, you know, investigative situation is, you can sometimes help yourself enormously. For instance, if you're being stopped and it's the one guy who you're dealing with, okay, you can be cooperative with that guy and friendly with that guy and do it, because that's the best chance you've got of going home. Okay. If he's asking you to do something, don't do it. You do it. The one guy able to go home. Once his buddies show up, okay, and you're suspected of DUI, you're probably not going to go home under those circumstances. if you were involved in a crash, okay, even if it's not your fault, all right, if the cops on your breath, chances are to take the ride. So you got nothing to gain by talking to them about anything, by cooperating in any way, by doing any little test, is to just shut it and see, because like I said, you're gonna go.
Well, those are the basics, the ABCs and the 1, 2, 3s. Listen, I agree. We could have gone on for a week on this. You know, there's so many things that we weren't able to talk about. We didn't get to really talk about DMV. We didn't get to talk about BUIs, but we did get to hit a lot of really interesting points. And again, you know, your contributions, both, you know, as a public defender with Essen and on your own, have really inured to the benefit of all of us. And so just on a personal level, for all the times that you've offered your time and your talent and your advice to me and to others similarly situated, thank you. And to all of the case law that you have been responsible for generating that have assisted the defense bar. Whoop, looks like we got cut out, or it looks like Carlos got cut out. Well, thank you anyhow, even though something went off with your computer and you're no longer there. But I want to thank you, Carlos, even though you can't hear me. Maybe you'll hear me when you play this back. Folks, thank you for paying attention today to this show. I know it was a long one. There was a little bit of technical talk, but DUIs are very technical cases. There's no such thing as a simple DUI. They're complex. And that's why when you get a DUI, you need to treat them like a murder case. And that's how lawyers like Carlos and myself and other DUI advocates do this. We look at them as if your misdemeanor may as well be a murder. And if your lawyer is not looking at it that way, then you've got the wrong lawyer. With that said, thank you very much for watching AYS 73. We will see you next week. We have another guest coming on. Oh, Carlos is back. I was thanking you in absentia.
Thank you
for everything. And I was just telling the folks that we'll be back next week with AYS 74. We have another guest coming on, a criminal appeals lawyer, although Carlos does plenty of appellate work as well. I have a guy who only does appeals that's coming on to talk about various appeals issues. But thank you again, Carlos, for coming on today, for sharing your expertise and your knowledge with the folks. It's greatly appreciated.
Thanks for having me, Michael. It was great. It was fun.
Awesome. And our producers will be putting this up live on various social media sites. They will send out the links to both Carlos and I after, and we'll put them up as well, or at least I will, so everyone will have access to them. Thank you all again. Carlos, thank you again. Thank you to Miami's community newspapers for producing this show as you do every week. We're very grateful. And we hope that you, the folks, the audience, appreciate and have gotten something out of this, including a few great pro tips. We'll see you all next week. Have a great week.
Take care. Thank you, Mike.